I'm an advocate. I'm a partner at Govilkar and Associates LLP. I'm a founder of Mediation Initiative. These are my qualifications, and I'm certified as a mediator through the Indian Institute of Corporate Affairs and ADR ODR International. As far as my hobbies go, I collect fountain pens and would like to start collecting watches. Now, this topic of mediation can go on for several hours. So, what I'm going to do is I'm going to quickly touch upon several topics that I believe that you should know about mediation. So, let's begin. So, point number one, what is ADR? Now, we have the primary means of dispute resolution, which is litigation. So, anything that happens in the courtrooms or an established structure of dispute resolution. And when I say established structure, I'm not just referring to the courts, but I'm also referring to the tribunals, right? So that becomes litigation, whether it's in courts or in tribunals. Then we have arbitration, which is one form of ADR, and mediation, which is another form of ADR. So ADR it stands for alternate dispute resolution. And we tend to use ADR as if it's entire terminology by itself, but the proper terminology is ADR mechanism, right? Alternate dispute resolution mechanism. So anything that is not in the courts or not in the tribunals is ADR. So arbitration is not in the courts and not in the tribunal, although it's called an arbitral tribunal. It's not like the revenue tribunals or the NCLT, the National Company Law Tribunal, or the Armed Forces Tribunal. It's not like that. So that is why, although it's called an arbitral tribunal, it's not in litigation. It's a different means of dispute resolution. It's an alternate means, right? So we have arbitration, and then we have mediation, which is obviously not litigation or arbitration and is completely different from the first two methods. To find the similarities between litigation and arbitration, we have to understand that the same law, almost the same procedures apply in litigation as well as arbitration. Now, somebody who is familiar with arbitration can say that no, but then the arbitrator has the liberty to set his or her own procedure for that particular arbitration. Yes, that is correct. But the procedure set in arbitration cannot go against the principles or the fundamental principles of the Code of Civil Procedure. So, yes, you can have flexibility in procedure in arbitration, but it cannot be against or in contravention or contradictory to the CPC, right? So we have to keep that in mind. Again, in arbitration, you can arbitrate civil disputes, whereas in litigation, you can get your disputes resolved, whether they are civil or criminal in nature. Again, in arbitration, you cannot resolve any constitutional matters. They can only be resolved either in the High Court or in the Supreme Court. So we have to remember these differences. In litigation and arbitration, you have an authority who is going to give you an order, a direction which is binding upon you, right? Now, in mediation, you don't have any law particularly that is applicable. The process of mediation is completely flexible, and I'll come to the process and the features of mediation. But what we have to remember is that there is no procedural law involved in mediation. Your dispute might be concerning several issues where different laws might be, but in mediation, you're not really arguing on the merits of the matter. You're not arguing on the law points as well. And what you're exactly going to do in mediation, I'll come to that in a few minutes. So, like I said, when we talk about ADR, there's another term which is conciliation as well. So I won't go into that, the differences between conciliation and mediation, but for the sake of this discussion, let's say that mediation is equal to or synonymous to conciliation. And I'm saying that because in the 2002 landmark judgment of Afcon's infrastructure, the Supreme Court of India has stated in no uncertain terms that mediation and conciliation are synonymous. In practice, however, there are some differences, but then maybe you can, if anybody wants to know, you can ask them in the Q&A session. So now, what exactly is mediation? These are some of the features in point number 2. It is confidential, it saves time and money, it is non-adversarial. All right. What do I mean by non-adversarial? What I mean is that in a mediation, unlike litigation or arbitration, it's not a situation where one wins and the other loses. In mediation, what is aimed for is a win-win situation. So that's why it is non-adversarial. The objective in mediation is to come to an agreement. So the basic principle of an agreement is that both parties have to agree on it. It has to be mutually acceptable, and only then will you come to an agreement. If the other party is going to lose, if they feel that they're not going to benefit from that agreement, it is simply impossible that they will agree to an agreement. Correct? So that is why it is non-adversarial. When I say it's flexible, the CPC does not apply to mediation. In fact, whenever you're talking about CPC and any procedure that goes against the principles of the CPC. You are actually referring to the process of whereby some, for example, a claim is filed or a suit is filed, and there is a written statement, there are issues, and then there is evidence, there are final arguments. But in mediation, none of these steps happen. The entire process of mediation is, first of all, the structure is defined by the mediator. And then what happens is during the process of mediation, this structure as it is set, it is followed, yes, but the mediator and the parties have the ability to alter the structure and alter the flow also as required. What you have to remember ultimately is that in mediation, the agreement is what is most important. If, let's say, the mediator has said that, okay, we will do the opening statements first, and then we will come to reflections and questions. But in a given situation, if the parties come to the table and suddenly they say that they start arguing, and then it becomes difficult for the mediator to control that argument, then the mediator, based on his skills and experience, may directly start asking questions and trying to control the situation as may be required. There is nothing that stops the mediator, but usually it is expected from the parties that a structure be followed. But again, I'm just stressing this point again and again, but you have to remember that it is flexible, and that flexibility we do not get in litigation or arbitration. Again, what happens in mediation is that because there is a mutually agreeable resolution to the dispute, it tends to preserve relationships. In adversarial dispute resolution, which is litigation and arbitration, there is most of the time a win-lose situation. So relationships can get completely destroyed, especially in family disputes. And when I talk about family disputes, it could be matrimonial disputes as well. Relationships can get completely destroyed. Even if you talk about commercial disputes, two business entities have established relations for several years. And then if this dispute escalates and comes to litigation or arbitration, there are allegations back and forth, and then egos get hurt. And then ultimately what happens is that the relationship gets destroyed. Whereas what is seen in mediation is that because these disputing parties enter into a dialogue, they enter into negotiations to see whether this and how this dispute can be resolved. It is seen that sometimes the resolutions that come out of mediation are far beyond the gamut of what was initially in dispute. They touch upon issues that were not even connected, because during the discussions, different issues come up and they feel that, okay, since we are talking about this, let's discuss this and let's find a resolution to this as well. Or there are some new ideas that are introduced. And it is very often seen that mediation does not just preserve relationships, but it also helps improve them. Now, coming to the last point of written agreement. In litigation and arbitration, like I said, in litigation, you have an order. If it's a suit, it's a decree. If it's some other kind of matter, it's an order. In arbitration, you have an award, which is deemed to be a decree, right? But in mediation, it's a written agreement. So now there are questions many times about the validity and the value of this written agreement. Well, this written agreement today will have the same value as any other contract, which is covered under the Indian Contract Act. So you have to realize that you can sign this agreement and then you will have to abide by the terms and conditions as it is normal contract. Then you will have to remember that there will be stamp duty applicable on it and all those things. You can choose to file a suit and get based on the consent terms that you have arrived at, and then file those consent terms in the suit and get a consent decree. So then this written agreement can get a better protection in the form of a decree if you do that. Or a third method that many people adopt right now is to deem these mediation proceedings as conciliation proceedings under the Arbitration and Conciliation Act of 1996. And then whatever is the conciliation agreement that you arrive at, you file that as an award. And then, like I said, award in arbitration has the same value as that of a decree. So you'll get the same protection as a decree. So this is what can be done right now. Okay. Now, like I said, there are several other topics that we can talk about under this heading of what is mediation, but considering the time that we have, I'm limiting it to this. If you have any questions, definitely ask them in the Q&A session. Now, in the mediation process, which is the third point, when there has been a reference to mediation, so first of all, you can ask, how does a mediation process even start? So as lawyers, it is your duty almost to advise your clients to at least try for mediation. If your clients agree, then it is your job, or if the clients feel that they know some good mediator, then you discuss this with the opposite party and you come up with the name of a mediator, you appoint that mediator, and the mediator will set up meetings, he will go through the process, explain to you what the process is, and then the mediation process would start. If your case is already in the courts, or if it is in arbitration, the arbitrator or the judge, as the case may be, might refer your case to mediation. It might be referred to a court annex mediation center, or it might be referred to a mediator that the judge feels or the arbitrator feels is skilled enough and experienced enough to deal with that dispute. So this is another method of how how a mediation process could begin. Now, generally what happens in mediation is that at the start of the mediation, the first session, you have opening statements made by, first of all, the mediator. Then you will have opening statements made by both the parties. And if lawyers are present in the meeting, then the mediator would also request the lawyers to make a statement. Sometimes the lawyers make the opening statements on behalf of their clients. That is also possible. But as a mediator, you have to understand that the decision and the outcome of a mediation session or of a mediation process is heavily dependent on parties themselves and not the lawyers. The lawyer's job in mediation is very different from that in arbitration or litigation. In arbitration and litigation, the lawyer tries to establish the rights of his or her client. Whereas in mediation, the lawyer is trying to ensure or should try to ensure that an agreement is reached and that his client gets the best possible terms. Now, you have to remember that the other side is also trying to arrive at the best possible terms for themselves. So unless there is an understanding of what works for both parties and what would do well for both parties, there won't be an agreement. So there has to be a mindset change for the lawyers in mediation. So that has to be kept in mind, right? So during the process, then after the opening statements, mediator will talk about the situation with the parties. He will ask them to reflect on certain issues. He will ask a lot of questions, and then there'll be the stage of negotiations. Now, just having said or talked about these 4 points of opening statement, negotiations, reflections, and questions, it might seem too easy, but it is not. First of all, the role of a mediator is to be a guide. There are two major kinds of or styles of mediation. One is facilitative and the second is evaluative. In facilitative mediation, the mediator should not or cannot rather express his views or give his opinion or make suggestions. Parties will always tend to ask the mediator about his or her opinion on a particular legal issue. But in a facilitative style, the mediator will not do that. His job is only to facilitate the discussion, the mediation, and not to tell the parties, okay, this is right and this is wrong. It is for the parties to realize and understand what is right and what is wrong for them. And the role and the job of a mediator in this facilitative style of mediation is to help the parties in coming to the realization of what is wrong and what is not, or what is right and what is not. It is a process of self-realization, and therein lies the skill of a mediator about how he helps the parties arrive at that situation where they start reflecting on the future of their business, or the future of their family relationships, or the future of how this dispute can affect them personally or professionally. Then these reflections will only happen if the mediator is asking the right questions. The questions can be indirect, they can be direct, they can be open-ended, closed-ended. Now, which kind of question and what question to ask and how to frame it properly is where the skills of a mediator lie. And these can come through training and experience both. So I hope that this quick introduction to this mediation process helped you at least understand what goes into the role and skill of a mediator. And of course, at the end of the mediation process, you come to the written agreement, which in some jurisdictions, it is a practice that the mediator drafts the mediated settlement agreement. And in some jurisdictions, the mediator says that no, he will not do it. And he will ask the respective lawyers to draft the agreements. This happens because mostly of liability issues. I believe that it is better to have the lawyers themselves draft the agreements so that later on there are no allegations against the mediator for any kind of partiality or favoritism, because the primary feature, let's call it a feature, of a mediator, of a good mediator, is neutrality. If a mediator is not neutral in any situation, he or she should not be a mediator at all, not even for a minute, because that will completely skew his approach to the dispute resolution process. And we don't want that in mediation. All right. Now, coming to the fourth point, what are the kinds of or the types of disputes that can be mediated? These can be civil and commercial, family disputes, vendor disputes, workplace disputes, customer grievances, even healthcare disputes. I have not written that here, but yes, healthcare disputes between doctors and patients. All right. Then moving on to the fifth point, which is legal sanctity, whether the outcome of a mediation is legally valid. Like I said earlier, yes, it is legally valid. These are legally enforceable agreements. Or for the law students here, all agreements are not contracts, but all contracts are agreements. So if your mediated settlement agreement falls within the definition of a contract, then yes, it is legally enforceable. Then, like I said, under the Arbitration and Conciliation Act, you can have the mediation process deemed to be a conciliation process, and then have the conciliation agreement settled as an award. And then we have the Mediation Bill number 43 of 2021, which has made provisions for even registration of mediation or mediated settlement agreements. It's still, the bill has yet to become a law. So let's see what happens. I'm going to talk about that a little bit in a few more minutes. As of today, there are a lot of challenges for mediation. There is a huge lack of awareness of mediation, what mediation actually is. What has been considered as mediation by most of senior lawyers right now is not mediation as it is meant to be. Mediation as it is meant to be and as it is practiced all over the world is very new to India. When I say new, it's still been almost 17 years now, because the Mediation and Conciliation Project Committee was established by the Supreme Court in the year 2005, and there has been several efforts gone into promoting this mediation process, but it's not countrywide. Based on my experience and discussions with mediators from across the country, what I've understood is that mediation has gained ground a lot in Delhi and in Chennai, and they are promoting mediation a lot in Madhya Pradesh as well. But for other jurisdictions, I have not heard very promising news. So if any of you are practicing in other jurisdictions, I would urge you to explore mediation as a dispute resolution mechanism. There is a lack of trust, and this stems from the lack of awareness. Because there is lack of awareness on how beneficial mediation can be and what the process actually is, people don't trust it. People feel that it is simply a waste of time. People don't realize that the outcome of a mediation is legally enforceable. Now, I don't expect you to be an expert in mediation at the end of this talk, but the hope is that by the end of this talk, you will have gained some idea and some interest in mediation, that you will explore this topic further and come to a realization of the various or understanding of the various facets of mediation, and hopefully you will promote it. Third point, which I have written here, which is lawyers and the judiciary. Many lawyers feel that if they promote mediation or if they go into mediation, they will lose a lot of revenue. But that's not really true, and that has not been the experience anywhere in the world. What will happen is probably you will have to change your practice from being a litigation lawyer to a mediation lawyer, and that's completely fine. You will just build a practice in mediation and you will earn from there. We hear this all the time, the number of pending cases in India. For any lawyer to file a case and for it to be heard on time in high courts and in the Supreme Court, the listing of cases is a big challenge. Even in the lower courts, yes, the date is given and it will be listed on the board, but then will it be heard? That is a challenge. But instead, your matter gets resolved in mediation and you earn from there, and from there you move on to the next case. It's not just about the revenues, but there's also a sense of satisfaction. Everybody comes into the profession with different objectives. Of course, one of them is to earn, and I'm not saying you should not earn from this profession. I'm doing it. I'm saying that mediation actually should become a recognized profession, a recognized and respected means of dispute resolution. But in mediation, there has to be, or there is an inherent aspect of being able to help the society in resolving the disputes that exist in it. If not everybody can be a good mediator, and you have to accept that. Just like not everybody can be a good lawyer, just like not everybody can be a good judge or a good for example, you might be practicing civil law, and then you say that I can't do criminal law. I don't have the mindset for it. If you're practicing in constitutional law and you have a practice where you are able to argue really interesting issues related to the constitution, everything else might seem boring to you, and that's fine. It's you are the person who is in charge of your career, and you have to decide what you want to do. But then if you are completely against mediation, you have to think about why you are against mediation and what exactly in mediation you're against. Because this is a discussion I have had with several lawyers, and fortunately for me, I was successful in able to convince them how mediation can be beneficial for everyone concerned, not just the parties, but even to the lawyers. The second is judiciary. There has to be a very proactive approach from the judiciary in referring matters to mediation. If the judiciary very proactively and often keeps on referring matters to mediation, this profession not, will develop, and not just that, but then the caseload will reduce. And that is one of the biggest challenges facing the judiciary right now. You will hear this news almost every single week about someone somewhere is talking about the pendency of cases. If you do follow legal news, then you must have realized that there has been these news items regarding the pendency and how the courts are functioning in the news very recently. So I would urge all the attendees to just think about these challenges and see how they can themselves and their clients can benefit from the process of mediation. Now, moving on to the next slide, we come to mandatory mediation. Now, here I must say that this kind of talks, I have already spoken quite a bit about the pendency of cases and how it can help mediation can help reduce that pendency. There are delays, like I said earlier, in the disposal, and then there is the possibility of early resolution. Now, having said that, if let's say what I'm saying today is adopted by the lawyers and the judiciary, and suddenly there is a big popularity and demand for mediation, one of the challenges is where are the good mediators available? Do we have enough trained mediators and mediation centers in India today? And the answer is frankly no. We don't have enough good mediators. If the reference to mediation increases exponentially, if it does, then we will have to also exponentially increase the training of good mediators. But even today, even if the matters referred to mediation increase by even, I don't want to put a percentage to it, but even if they increase substantially, the existing lot of mediators can sufficiently and adequately, and this is my belief, and if you have anything that proves me wrong, definitely please do share that. But I do believe sincerely that these challenges could be these cases referred to mediation can be successfully resolved by the present lot of mediators. And with the promotion that mediation has been receiving over the past 1.5 years, there are more and more mediators being trained. So it's a continuous process. Now, coming to the 8th point, career opportunities. So whatever I have said till now should give you an idea of the immense career opportunities that exist in mediation today. If you have the mindset of being a mediator, well and good, you go and be a mediator. If you feel that I can't be a good mediator, but I can help someone help someone in a mediation as their lawyer, then be that. Because like I said, a lawyer in mediation requires a different mindset. You have to be no doubt good in your law, because if the agreements if the agreements are not going to stand up to the law, then that agreement is not going to be enforceable, right? So it's not going to be a contract. If, for example, in a given mediation, you come to a situation where there is a debatable issue and you know that there is some judgment in the Supreme Court which is definitely going to help you and it supports your cause. So in that situation, you know that you can't concede that point because the law supports you. And if you are a good enough lawyer in mediation, you will help get that point across to the other side by communicating in a proper and effective manner that we can't agree to this because the law supports us. But it can't be adversarial. You have to be diplomatic. You have to be strategic enough. You have to be convincing enough and help everybody understand that it is in everybody's benefit that the agreement is arrived at. Because you may be right on one point, but the other party may have some other point that the law supports them on. So as a lawyer, you will play a very important role in mediation. Now, coming to the Mediation Bill number 43 of 2021. I'm just going to refer to a few of the provisions in this bill. And I don't know if most of you know this, but this bill was introduced last November in 2021. And then after that, in July 2022, the Department-related Parliamentary Standing Committee on Personnel, Public Grievances, Law and Justice has given its report and has given certain comments on what provisions of the bill. So I would highly recommend that you go through this standing committee report because it will give you a lot of insights of what the standing committee is thinking about. Now, this report says that this committee held 10 meetings spanning over more than 17 hours in all and recorded views of more than 125 witnesses and has come up with these suggestions. But when the bill was drafted, it was drafted with the help and participation of some of the best mediators in India who have been practicing mediation for ages. They have been recognized internationally as being excellent mediators, and they tried to introduce a lot of internationally accepted practices in this mediation bill. So what ultimately happens of this bill, we don't know. But I have gone through this bill in depth, and I believe that it has covered a lot of aspects and would be a very good place to begin with, but only time will tell what happens ultimately in the parliamentary discussions and what the final law is. But let's talk about pre-litigation mediation. Now, this pre-litigation mediation is mandatory mediation. So before you go to the court or before you go for arbitration, if you have a mediation clause built in your arbitration clause, you will have to go in for mandatory mediation. If the mediation fails, your rights are not affected in any manner, and not just because of this mediation bill. But the beauty of mediation is you go in for mediation, you will spend some time and money, but even if the mediation fails, your rights do not get affected, because first of all, there is no order. Everything in a mediation that is discussed or shared is completely confidential. So unless that information was already available with you or in the public domain, it cannot be used later on in arbitration or litigation. So from my perspective, pre-litigation mediation is really beneficial. It also gives a time frame within which that mediation should be completed. But take a situation where the other party just does not come to the mediation meetings. What happens then? Well, the mediation fails. We are not talking about a situation where there is a party with mala fide intent and he or she or that entity wants to defraud you or create problems for you. We are not talking about those situations or those kinds of people or entities. We are talking about disputes where there is a genuine dispute and people want to resolve it. And that is where mediation can benefit tremendously. Even if people want to resolve it, sometimes they feel that it simply cannot be resolved by discussions. But it has been the experience of mediators all around the world for several decades that even when people feel that mediation will be pointless, they have come out of mediation with a successful agreement, resolution to their dispute, with a improved relationship as well. So do remember that it's not a waste of time having disputing parties discuss and delve into the nitty-gritties of the disputes helps them realize how they can move ahead and how they can possibly come to a resolution. It's not an easy process, but that's where the skills of the mediator lie, right? Then the mediation bill makes some differentiation with respect to the kind of mediation, whether it is domestic mediation, community mediation, international mediation. Now, there is just like you might be aware about the New York Convention on Arbitration, there is a similar convention for mediation, and it is called as the Singapore Convention. The Singapore Convention was signed by India, and once this law comes in and India ratifies the convention in India, then yes, it will be a big step forward. But the Singapore Convention is only about or for commercial disputes, but the mediation bill covers all kinds of disputes. So remember that the mediation bill aims to cover all kinds of disputes and not just commercial disputes like the Singapore Convention. And in the category of international mediation, yes, the Singapore Convention is hoped to be incorporated. The mediation bill also makes a special provision for online mediation, which is amazing because with COVID, online dispute resolution, or ODR as it is called, has gained a huge impetus. And I believe it's really a big step forward that people have adopted technology for dispute resolution. And I sincerely believe that online mediation or even online arbitration and online litigation should be given a lot of encouragement for lawyers who have to travel to different courts every day, or even if they are just traveling to one court but they live far off. It's a big boon if they can just appear from their offices or from their residences for any matter. So making a provision for online mediation, I believe, is a big positive in this bill. And then the mediation bill also has made provisions for amendments to several other acts like the Contract Act, the Arbitration Act, the Industrial Disputes Act. So there are several such amendments also provided for in this bill. Then lastly, the mediation bill envisages the creation of three kinds of entities. One is the Mediation Council, which will be kind of like the governing body for all mediations in India. Now, I must tell you that the creation of a mediation council has been a topic of much debate, and there are very senior and experienced mediators where they feel that mediation as a field should not have such regulation, because the essence of mediation is voluntariness, it is confidentiality. And when you bring in regulation for this essence of freedom and voluntariness and confidentiality may be lost. But only time will tell what kind of regulations this mediation council may bring in. The other objection to this mediation council is its composition, wherein it is felt that the composition has provisions for a lot of government influence, which should not be the case, and there should be more presence of professional mediators, or in a broad category, alternate dispute resolution professionals. So that is one suggestion that is being made. Then we have mediation institutes. Now, these institutes will primarily be responsible for providing mediation related training and education. Again, the rules and regulations and the criteria has not yet been specified. We'll have to see what happens related to that. And then ultimately we have the mediation service providers. Mediation service providers are those entities which will be similar to arbitration centers, where these centers or these service providers will specialize in providing the infrastructure and the facilities for conducting mediations. And they will also have to adhere to certain standards and rules and regulations, which, like I said, we will need to see what they will be when the law is passed and the rules come out.
How do we convert, hardcore contested divorce cases into mutually consented ones? Or would an alternative approach, in case a client comes to me, can I suggest mediation at the initial stage before we go to the courts and file these cases?
What I have been trying to do, I'll give you my personal experience, because there is no tried and tested formula as such, because it depends from case to case. What I
Right.
to do with all my clients, whenever I feel that a dispute is ideal for mediation, is I try to explain to them the benefits of mediation. I try to explain to them the process of mediation and how it will benefit them. I
Uh-huh.
try to tell them, I try to convince them not to wait till the situation reaches a point where there is so much acrimony and bitterness between the parties that they don't even want to see each other's faces. So I advise them to start or at least attempt mediation, because I just tell them there is no harm in mediation, right? You're
Hmm.
not, mediation is not going to affect your rights. There is not going to be any order in mediation. If you, for example, if it's a matrimonial dispute and the husband says that, okay, I'll pay you let's say 15,000 per month as alimony or maintenance, and the dispute and the mediation ultimately fails, let's say if it's a divorce proceeding later in the court, the wife can't say, no, he had offered me 15,000 and now he should pay. No, she can't do that, because whatever offer was made during mediation was completely confidential. So you can explain to them the aspect of confidentiality as well. But ultimately, Mr. Singh, what really matters is how you're able to convince them. And it really is your skill about trying to convince them to go for mediation. Now, since you deal with these matters, you are aware how stressful it can be for families.
Extremely.
Extremely stressful, right? I'm dealing with a matrimonial dispute right now where just like any other, there is a divorce petition, there is a domestic violence complaint filed, and there is a 498A case. It's almost like today, if you file one proceeding, the other two have to follow. The family is dealing with all three, but at the very start, when the husband had come to me, I had advised the husband to not file any case, to not file any divorce petition, and to first attempt mediation. Fortunately, the husband agreed with me and listened to me, and he tried his very best to have his wife go for mediation and counseling. But the wife was so adamant that she refused. But now, I mean,
Okay.
as now in a contested proceeding, what I am able to do now is that I am able to use that. I'm able to say that yes, the husband tried for mediation, tried for counseling, but the wife refused.
Okay.
I'm also advising a company on corporate matters, and they're actually in a big dispute with a huge social media company. They feel that they can't really challenge that social media company, but I'm telling them that don't let this escalate, go for mediation. They also have a workplace dispute going on, and the dispute is between the CEO and the HR department. So I'm just telling them to start discussing and having the discussion and having somebody mediate the dispute, and not let it come to a point where the HR department and the CEO are at such loggerheads that it becomes a really serious issue. So, Mr. Singh, I hope that kind of helps you, because there's no straightforward or clear-cut formula of how you can
No, I
convert
get it.
really contested parties to go for mediation.
So just made one concern here.
Yes,
Once
sir.
the party comes and approaches me, that is all right. I mean, my party would of course be convinced to go for mediation. How does one persuade the other party? Does one so do I send legal notice to the other party, asking her or him to attend such proceedings so that we could arrive at a certain
Yes,
consensus?
yes, yes. So again, like I was saying, a lawyer in a mediation has to adopt a different mindset. So you will have to change the language in your notice as well. It cannot be the kind of language that we normally use when
True.
in litigation. It cannot be so direct. It cannot be worded in such a manner that they feel affronted, or they feel that they need to respond immediately in such a manner that we will teach them a lesson. So it can't be in that language. It has to be very approachable. It has to be mild. It has to be inviting. It has to make them feel that this person is actually interested in settling the dispute. So you have to draft your notice accordingly.
Right.
And hopefully also speak to the other side's lawyer, explaining to them, okay, let's try for mediation, and hopefully we can settle this dispute.
Thank you so much.
How in a domestic violence case, we request JMFC or court to appoint mediator for dispute resolution amicably?
See, DV proceedings, and a mediator can always be appointed. In one of my cases, in Mumbai you have a metropolitan magistrate. You don't have JMFCs. So the metropolitan magistrate appointed a mediator, referred the matter to mediation, and appointed a mediator. And the metropolitan magistrate did it on his own. I didn't even have to make an application. But you
Okay,
can
sir.
always make an application for referring the matter to mediation. See, remember, at least in Mumbai and the surrounding areas, I know for a fact that all the lower courts have been requested to promote mediation. So it is possible that it is the case in other states as well. But I don't think anybody would refuse to refer a matter to mediation unless there are other facts and circumstances peculiar to that case.
How to work on situation wherein the opposite party has unjustifiable demands while we are trying to settle matter amicably by mediation or conciliation?
So this is such a classic extreme example, right? You are talking about unreasonable
Demands from opposite party, yes.
Exactly. And that is what the mediator tries to help the parties understand. Right now, when you say unreasonable, is it you are making that conclusion that it is unreasonable? But now, like I said, we can't really address parties, or we can't help resolve disputes where there is a malicious or mala fide intent. So if somebody is making unreasonable demands with a malicious intent, then mediation cannot succeed. That's a definite answer to that. But you are calling it unreasonable from your perspective. From the other person's perspective, it might not be unreasonable. So in situations, and remember that mediators face these situations all the time, where one party makes a demand and the other party says, no, this is impossible, this is unreasonable, and so on and so forth. But it is a mediator's job to help both the parties understand what things are possible. And if they want, and if they realize that a resolution to this dispute is in their best interests, they will come to a mutual agreement. They will come to an agreement if they want to resolve the dispute. But if they just want to keep fighting, you can't help it at all. If somebody is adamant and just hell-bent on creating problems, see, mediation is not a magic wand, but it is a means of dispute resolution that has been proven to help millions across the world over several decades. That has been the experience, and that is something that simply cannot be denied. That is a fact. But at the same time, just like in any other situations, mediation is not applicable in situations, or cannot help in situations where, like I said, and there is malicious intent.
For law graduates, where we can find a good institute for the courses on mediation?
So there are two things that I have come to realize over the last couple of years. It's the last couple of years where mediation training has gained a lot of ground. There are mediation trainings happening where the trainers that organizer is able to bring together. The trainers are really good. The subject, the matter that they are training you on is really good, but they don't have some kind of accreditation. And then there are other institutes where it's just the same thing, where the trainers are good, the course material is good, but they have some kind of accreditation. So does this mean that you cannot practice mediation is if you go for some training without accreditation? No, that's not it. Mediation is a skill that is developed. You train for it, you get the knowledge. Then just like advocacy, it's a skill that you develop and keep on developing over the course of your career. And mediation is the same thing. There are advocates who have just an LLB and who have done extremely well in their careers. And there are people who maybe have a PhD in law and they have not done so well. So accreditation may not necessarily mean that you will be successful in mediation. Accreditation helps in sometimes getting jobs or getting empaneled somewhere. But as far as India is concerned right now, I can't really tell you which course to go for, but what I will suggest is to look for the kinds of trainers that are going to train you in that training session or that training program and the course material. So I would request you to focus on that more rather than just the accreditation, because you have to kind of see it as a package at this moment. After the mediation law comes in, then we will have more clarity about which accreditations are recognized, which are not, and what are the implications of that. We will have to find out at that time. But as of now, I would suggest that you look at the course material and the trainers.
Can we apply mediation in 420 cases, and how one can be a mediator?
How one can be a mediator? Like I said, see, mediation is a skill that you can learn on your own as well. I don't want to make it sound too simple, because it's not a simple skill. You can be a wonderful mediator right now in your personal life as well. Right now, I mean, nobody can know unless you tell us. Are you able to resolve disputes in your personal and professional life on your own? Are you able to make people come to an agreement where they are both happy with the resolution? So you can develop these skills on your own by self-learning, talking to people, meeting people, getting trainings, different kinds of trainings. It's a skill that you will have to keep on developing. Don't recollect the other part of the question.
Yes, sir. He is asking, can we apply mediation in 420 cases?
Yeah, so I just checked on Google and it says that 420 is compoundable. So yeah, so any compoundable offense can be referred to mediation. Definitely. It's only in cases of non-compoundable offenses that the question arises. But for all compoundable offenses, yeah, go for it. Go for mediation. There's nobody to stop you.
Please throw some light on the conciliation agreement. How can one convert a general outcome of a negotiation to a conciliation agreement?
Okay. So you don't really convert it. Okay. So when you have to follow a process where what happens is the conciliation process begins with a reference to a conciliator. And then after the conciliation process, there is a conciliation agreement, which is then deemed to be an award. Now to understand this better, I would request you to take a look at the provisions relating to conciliation under the 1996 Act. That will help you understand this better. So when you are negotiating and when you come to a mediated settlement agreement, that agreement can be deemed to be under the Conciliation Act and can be deemed to be a award thereafter. I hope this clarifies it. And I would also urge you to go through the Mediation Bill, because that also refers to some amendments that are going to be made in the 1996 Act. That will further clarify this situation for you.
What steps can be taken by law students if they want to pursue a career in ADR, especially in mediation?
See, I get this question all the time, and I have interns also in my office, and what happens is many people want to start a career in ADR. Now, like I said, ADR is, besides litigation, it's arbitration and mediation. Now, what in ADR? So I know this person who's asking the question is asking about mediation, but I'm talking generally. The general appeal is towards arbitration. Now, as I explained earlier, arbitration is a different forum, but the same laws as in the courts are applicable in arbitration. Only if you go into international arbitration, then it becomes really interesting, where you have laws from different jurisdictions and you have to understand their interplay. But that will happen even in litigation, because if there is an international agreement and that is going to be decided in the courts, then there will be an influence of different laws from different jurisdictions, and the courts will consider those, because it will also depend on how the agreement has been structured, based on which the dispute arises. So if you're looking at international disputes, then whether it is courts or an arbitration, that interest level is definitely high, and the complexity of everything. But if you're looking at domestic arbitration, then it's the same laws that apply in the courts that are going to be used in arbitration. The Arbitration Act regulates the procedure in arbitration, but like I said earlier, this procedure also cannot be against the fundamental principles of the CPC. So unless you know the CPC, you will not know what the fundamental principles are. So this is about arbitration, but and like I talked about mediation, if you want to develop a career in mediation, there are immense opportunities. There are plenty of cases available. Now, whether they get referred to mediation or not, that is the challenge that we have to address today. And popularity in mediation can only come about if law students, young senior lawyers, judges, people from all the sections of the profession promote it. You will find companies going to the big law firms and they will say, let's go for arbitration or litigation. Why waste time in mediation? And again, I believe that this stems from a lack of awareness and understanding of the process. Now, there is a gentleman, he's a partner in ADR in one of the biggest firms in India. I met him in Ahmedabad in the month of April, and I was asking the same thing. I mean, how, as one of the partners for ADR in one of the largest firms in India, are you promoting mediation? And he said that their experience has been that if you help clients resolve disputes quickly and in a smooth manner, they are repeat clients. So it was very heartening for me to hear a person at such a high position say that this is the approach they are adopting. So if more and more firms and lawyers and companies start adopting this process or this approach, then yes, it will become popular. And if you want to make a career in mediation, then start promoting it, start talking about it, start advising. If you're a law student, then start having mediation moods, start talking to lawyers and say, okay, why don't we try mediation? Introduce mediation as a subject or undergo trainings while you're a law student. And trainings actually apply to law students as well as current lawyers and even senior lawyers. So yeah, that is my advice to you. Thank you so much for inviting me and giving the opportunity to speak on mediation here.